Our social policies, infrastructure, and legal provisions must be regularly updated to support families. My ministry has been doing so. The proposed legislative amendments we are making to the Women's Charter today is one part of this larger effort. Specifically, the proposed amendments to the Women's Charter will, firstly, help support younger couples in their transition into married life and parenthood, better protect the interests of children affected by their parents' divorce, thirdly, allow incapacitated husbands and ex-husbands to apply for spousal maintenance when there is a clear need, fourthly, void marriages of convenience, fifthly, better support vulnerable persons in family violence and crisis situations, and lastly, strengthen law enforcement against online vice. We will now amend the Women's Charter rules to extend the marriage preparation program to all marriages where one party is a minor. Beyond legislation, we will also enhance the pre- and post-marriage support continuum for this group of couples. We will put in place group marriage education programs, one-on-one marriage assessments, and post-marriage support sessions by 2017. Now, even as we try to strengthen marriages, there will be those that have irretrievably broken down. Divorcing couples and their family members go through periods of anger, anxiety, grief, and stress. And the children are often the ones most adversely impacted when caught in the middle of the parents' fight. We are therefore introducing a new Section 94A in the Women's Charter to require divorcing couples with minor children who are not able to agree on all matters of divorces to attend a mandatory parenting program before they can file a divorce. For a start, those with at least one child aged below 14 years will be required to attend the program. We plan to eventually extend this requirement to those with children aged below 21 years old. The new pre-divorce mandatory parenting program will cover a range of issues that will have a tangible impact on children, such as housing, school, care arrangements, and bread and butter issues. These practical aspects, when overlooked, add unnecessary turmoil to a child's life post-divorce. Today, under the Women's Charter, maintenance may be ordered for two broad categories. The first is maintenance for children. Now, the second category of maintenance is for a spouse or ex-spouse. This is the focus of the proposed amendment. Today, a woman can seek spousal maintenance from her husband or ex-husband. The law, however, does not enable men to seek spousal maintenance from their wives or ex-wives. Recently, one of our divorce support specialist agency highlighted a case they handled. This concerns a man with a professional job. He was unfortunately struck with a debilitating illness while on an overseas work assignment. The illness left him mentally incapacitated and unable to work. His wife, equally successful in her career, divorced him, and now he has no way to support himself. In yet another case, my parliamentary secretary met a male resident who became severely disabled after a serious work accident. His wife divorced him. He is very bitter because he has no recourse for support, and despite years of having provided for his wife and family. We have set 3 clear criteria that must all be met. Only a man who is firstly incapacitated before or during the course of the marriage, secondly, unable to earn a livelihood, and thirdly, unable to support himself, therefore can claim maintenance. He must also be unable to support himself at the time when the maintenance application is heard. Now, for clarity, I'll give some examples which will not be covered. And these include, 1, an incapacitated husband or ex-husband who is able to earn a livelihood sufficient to maintain himself. Secondly, an incapacitated husband or ex-husband who has other means, such as income from investments or insurance payouts, to support himself. And thirdly, an ex-husband who became incapacitated after the divorce has been finalized. An ex-wife is not expected and does not have any obligation to provide spousal maintenance if her ex-husband does not meet the criteria up to the point of divorce. Now, during our public consultation, we also received a lot of feedback on maintenance enforcement. I think many of us feel very strongly about these issues. I certainly do. We have received many heartfelt appeals and letters who talk of maintenance payments slipping, being irregular, not being paid. I can understand how frustrating this can be for an ex-spouse who is not only entitled to, but who relies on the maintenance to keep the family going after divorce. Now, we will extend timely financial assistance to vulnerable wives and ex-wives and their children in cases where the husband or ex-husband genuinely cannot pay maintenance. For example, he could be in jail or has had a serious accident and cannot work. Such wives or ex-wives will be directed to my ministry's Social Service Office for financial assistance. Now let me move on to the issue of protection. Men, women, and children who experience family violence require help. Today, in the event of violence within the family, a married man or woman below 21 years of age has to rely on others, such as a parent or guardian, to apply for a protection order on his or her behalf. Given that most married persons below 21 years old already have familial responsibilities such as care for children, Section 65 is to be amended to provide for married or previously married persons below 21 years old to apply for protection orders for themselves and their children. Some women and girls in crisis situations may at times need temporary emergency accommodation at places of safety, such as crisis shelters or residential facilities. The bill introduces new community-based care options by allowing the Director of Social Welfare to also place a vulnerable woman or girl below 21 years of age into the care of a fit individual. This could be a relative or friend who could provide support in a home environment and not only in residential facilities or shelters. The rise of online platform and social media also pose new dangers to victims of abuse and challenges to the professionals who protect them. A new Section 177A will prohibit the publication or broadcast of any information in the mass and social media that would reveal or is likely to identify the location of the shelter, residential facility, or its residents. This is to better prevent perpetrators of violence from harassing, intimidating, or harming persons residing or working at places of safety. A related amendment is made to Section 153 to prohibit publishing of information via online media which may lead to women and girls being identified in certain in-camera court proceedings.
Madam Speaker, the Women's Charter is an important piece of legislation in Singapore. It was passed in 1961 to protect and advance the rights of women and girls in Singapore. At that time, the typical household division of labor was such that women would take care of the family at home while men go out to work and bring the bread home. Many women, due to the lack of education and little control over or access to resources then, were often bullied and in worse instances faced domestic violence. Therefore, I believe the Women's Charter passed in 1961 was a progressive and much needed piece of legislation. Fast forward more than 50 years to today, Singapore has progressed significantly and women today have made huge leaps on many fronts. Singaporean women today are driven and well-educated. We are capable of holding our own at workplaces, and with jobs, this means that we are or can be financially independent, generally speaking. Moreover, we have also observed a small but growing group of men who give up their jobs to devote their full time to caring for their families. Therefore, it is timely to review the Women's Charter and update parts of the Charter to offer somewhat more gender balance. With that, I support the provision in principle. I do have a few concerns that I hope that the MSF can address. Firstly, what safeguards will the MSF put in place to ensure that even though the applicant is incapacitated and appears to be the weaker party, maintenance will be granted only on legitimate grounds? For instance, what if the applicant had not even contributed to the raising of the family before he was incapacitated? Number two, how will the MSF ensure that this provision will not overburden the ex-wives, who are also granted custody of their children precisely because they are now the more able party? Thirdly, what about the divorced women today who are still not receiving their monthly maintenance? While the provision is a step in the right direction, I do urge the MSF that it will continue to strengthen its implementation and support to the ex-wives who need but have yet to receive their monthly maintenance. Finally, while I am encouraged by the MSF's move to provide more protection and support to children affected by their parents' divorce, the ideal must be to build strong families in Singapore. As I have said earlier, the biggest victim in a divorce would be the children. Not only do they have to cope with the immediate pain and anxieties, instability, and other adjustment issues, they also risk suffering longer-term effects, such as trust and relationship problems in their adulthood. Hence, we must not subject innocent children to such pain as far as possible. Hence, therefore, I hope MSF will continue its work in anchoring the ideal of strong families and work closely with other ministries to ensure that our policies help young couples build strong families that can stand the test of time.
One of the issues that's usually very difficult for couples to deal with is the arrangements in relation to custody, care and control, and access of the children upon divorce. In my view, such actions are harmful to the children's mental development in the long run. The negativity which the parents show towards each other can have a traumatic impact on the children, and usually these children are unable to voice out their emotions to the parents. Therefore, the divorce process should be child-centric and protect the interests of the children. The intent of introducing a parenting program is clearly noble. However, for the initiative to be truly successful, the parenting program itself must be effective. In implementing this program, I hope attention will be given to develop a curriculum that goes to the core of the problem and is going to be useful for the parents. I thank the Minister for earlier giving an insight to some of the items that would be covered in the program. Such programs should address the parents' needs, cater to their various family situations, and be simple enough to be understood by all. I would like to add that the execution of this program is important, otherwise it will be seen as just another procedure that the parties would have to go through to obtain their divorce. In fact, the Minister mentioned that there were concerns raised during the public consultation exercise. I would like to highlight that there must be sufficient capacity to schedule parties for programs in a timely manner so that the divorce proceeding is not delayed. If there are insufficient slots, for example, parties would have to wait before they can attend the program, and they may be delayed in filing their divorce papers. This can cause angst and frustration amongst the already stressed and highly emotional couples. Divorce is an agonizing process, and we should not delay or complicate the procedures unnecessarily. In keeping with the making divorce process more child-centric, I also welcome and appreciate the proposed amendments to Section 50 of the Women's Charter. Where children are involved, whether they like it or not, couples will continue to be in long-term relationship. An adversarial court process can be damaging to parties, and in particular, their children. It is therefore important to have processes that in some way heal parties to help them cope through the situation. I believe that counseling and mediation are key healing processes, and it is useful to extend the variety of such processes.
Another area that garnered much interest was spousal maintenance. Members have put forward a wide spectrum of views. Members such as Mr. Seah Kam Peng, Engineer Dr. Lee Bee-Wah, Associate Professor Daniel Goh, Lewis spoke about moving towards more gender-neutral approach. I hear you. I fully understand, because we do see instances where there might seem to be a compelling need to move along these grounds. But on the other hand, as I've highlighted, there are also other views. Ms. Rahayu also expressed her concerns against it, reminding us that many women are still vulnerable. And her sentiments echo a Straits Times commentary in October last year, which was titled, "A Reality Check in Gender Equality." And let me quote, "Given the reality, supported by surveys, that the burden of care for children and the elderly still falls largely on the shoulders of women, the current law remains relevant." I think attitudes are changing. I think they are gradually shifting towards greater gender neutrality, but we believe at this stage it's best not to rush and force the pace. I also heard concerns about extending maintenance to incapacitated husbands, such as those shared by Ms. Tin Pei Ling. The scenario of women of lesser means struggling to support herself and the children is a big concern. What more if such a woman has to maintain an incapacitated ex-husband? So to reiterate, the incapacitated husband must meet all the criteria set out before he can apply for maintenance from the wife. Now, even if all of these criteria are met, it does not mean that the husband or ex-husband will automatically be entitled to maintenance. Ms. Lily Neo expressed concerns for women who may be caught up in these situations where it will be a strain for them to provide maintenance as well. So the court will have to consider all circumstances of the case, including the income, the earning capacity of the wife or ex-wife, the financial needs of both parties, and the needs of the children. This is no different from the considerations for maintenance for wives and ex-wives, where they are also not automatically entitled to maintenance, as highlighted by some of the examples that you've mentioned earlier. To sum up, while we may review this in future, the proposal to extend maintenance only to incapacitated men is a calibrated measure. It strikes a balance at this stage of our societal development.